Introduction to terminology of various legal instruments. In this lecture, we will discuss the significance of legal instruments and the technical aspects of each of the instrument. As the relations of individuals are regulated by legal sanction in international law, to regulate the day-to-day relations between the states, they enter into a number of agreements. These agreements are commonly referred to as treaties. However, due to the technical procedures involved in the implementation and agreement process, they are referred to with a number of other names. The commonly used names are treaties, covenants, charter, conventions, protocol and declaration. Nevertheless, all of the agreements establish legal relations between states and crystallize rules of international law. From the evolution of international law to date, numerous agreements entered between states. These will be described in brief in order to know their significance and the importance of these agreements have in international law and as well in human rights. Before discussing the various types of instruments, for a general understanding, let me clarify the procedures adopted for the binding nature of these instruments. In international law, any agreement entered between the states will not automatically come into force. According to the general principles of international law, any treaty negotiated and signed by the states will not come into effect automatically. In the negotiating stage itself, depending on the number of states willing to sign the document, they fix a certain number of states to ratify such agreement. Accordingly, after ratification of such number of member states, then the particular document will come into operation. This means any legal instrument entered in a particular year may come into effect either immediately or may take a long period of time to come into existence. For example, the Vienna Convention on the Law of Treaties was adopted by the states in the year 1969. Here, one has to remember that in international law, most of the agreements or instruments are named after the place in which the states negotiate or sign the instrument. So, this instrument came into effect only in 1980. Though an instrument coming into force may be another year, it is still linked to the year in which it was originally adopted. Even if an instrument has come into existence due to ratification, it will be binding only on those states which have ratified such agreement and not on the states who affixed their signature. At times, even if a state ratifies a particular instrument, it may expressly inform the Secretary General of the United Nations, whose office is considered as the depository of all the instruments in international law, that it is not going to accept all the provisions of the agreement and reserving some provisions. If international community accepts the request, then its obligations are limited only to such provisions which are not reserved by. This provision has been given in order to facilitate the states to take care of their local interests within the country. For example, in the Convention on the Elimination of All Forms of Discrimination Against Women, popularly referred to as SEDA Convention, the Government of India has reserved a number of provisions stating that if it accepts such provisions, it may not be able to pass necessary legislation in municipal law, as it would result in disturbing the communal harmony between various religions. The provision for common civil code is one among the main provisions that has been reserved by Government of India. Now, let us examine each of these provisions independently. Treaty. The term treaty has not been defined exactly until the year 1969. In 1969, to develop the legal principles and the binding nature of the legal instruments, a convention was adopted, namely Vienna Convention on the Law of Treaties 1969. According to the convention, a treaty is an international agreement entered between states in a written form regulated by the principles of international law, whatever may be the title of such agreement. The principles of an instrument may be stated in a single document or may be spread into two or more documents. In case if they are spread into more than one, all the documents and principles are to be read together for the binding nature of an instrument or treaty. A treaty is generally classified as bilateral or multilateral treaty. Bilateral treaty. Bilateral treaty means any agreement entered between two nations confining to the matters relating to them with any specific aspect. For example, India enters a bilateral treaty with USA for the supply of nuclear energy is a bilateral treaty. The treaty will come into force without ratification and reservation. These treaties will be in force till the time the agreement achieves its objects. Once the purpose of the agreement is over, then by notification it will be terminated. In exceptional circumstances, some of the agreements may require the approval of not only the government, but the legislative approval of the country, that is the parliament or congress or whatever may be the name of the organ in that country. Multilateral treaty. Multilateral treaty means an agreement entered by majority of states to establish new principles of international law or to codify, to accept existing customary norms to be bound by them in their multifarious regulations. These treaties are similar to that of legislations that are adopted by states in their municipal or internal domain. These treaties are similar to that of legislations that are adopted by states in their municipal or internal domain. These treaties are mainly entered if there is no unanimous opinion is arrived at by states in their bilateral treaties, or if a principle has gained uniform consent by states through bilateral relations or to lay down new norms of international law. Accordingly, a multilateral treaty can be defined as an international agreement to lay down uniform norms to be followed by the states in their legal regulations between them. Since the beginning of 19th century till now, remarkable number of multilateral agreements have been entered by the states. In general, multilateral treaties are referred to as conventions. These treaties impose an obligation after the technical formalities of signing, ratification, etc. The states are bound to give effect by passing appropriate legislation in tune with the principles of international law. For example, the TRIPS agreement necessitated the government of India to enact specific legislations or bring in modifications in the existing enactments such as Law of Copyright, Patents Act, Trademarks and Designs Act, etc. Then the next one is convention and covenant. A convention or covenant are multilateral agreements entered by states to lay down or to define the existing norms of international law uniformly. These agreements codify the existing law or customary principles or lay down new norms. The only difference in their terminology, a convention may take long time for the states to adopt into their municipal legislations after the technical procedures are completed. At times, they may even renegotiate to settle the conflicting issues by entering into bilateral agreements. Whereas, in the case of covenant, they are bound to implement the norms by enacting a legislation. The covenants normally deal with the general welfare of the people of the world, establishing duties on the states to protect the interests of individuals at the state level. The covenants on civil and political rights, economic, social and cultural rights have led every government to give effect to a number of rights and duties guaranteed to individuals by the states. Declaration. Declaration means a set of principles laid down by an international body or organization like the United Nations, recognizing the significance of such principles to be followed by states. It means declaring a policy to be adopted by states commonly in future, either to give effect directly or by permitting them to enter into multilateral agreements. Declaration being primarily policy document which only enlists the views of an international organization, it has no legal validity and no binding nature on the states. In order to give effect to such declarations, normally states, after deliberations to crystallize the principles as binding legal aspects, enter into either in one or more covenants. For example, the Universal Declaration of Human Rights, adopted by the United Nations in the year 1948, later crystallized into Covenant on Civil and Political Rights and Covenant on Economic, Social and Cultural Rights. Protocol. A protocol is a diplomatic word used in international relations. However, in the perspective of international agreements, in any agreement entered into by the states parties and later they want to amend any provision or include any new provision, they have to adopt amendments. These amendments will generally be in written form and need to be adopted after all the formalities such as negotiation, communication, signature, ratification, reservation, etc. are completed. After the formalities are completed, they will be annexed to the main agreement, treaty, convention, covenant, etc. In the municipal law, once a legislation is adopted, any changes are incorporated through an amendment. However, in international law, since no legislative authority exists, they have to follow all the procedures that are applicable to an agreement, even in the case of a protocol, and then annex it to the main text. In case if a state ratifies a convention and has not ratified the protocol, then such protocol will not be applicable to such states which have not ratified. For example, India signed the Covenant on Civil and Political Rights, but not ratified the protocols. Hence, the protocol provisions of abolition of death penalty are not applicable to India and such states which have not ratified it. In a brief manner, a protocol is an additional agreement added to a main agreement which may amend the existing provisions or bring in new rules need to be bound by the states. These have to be technically adopted after all the procedures that are needed for the enforcement of an agreement. Conference. In international law, conferences play a very vital role. Before formulating new rules or to sort out existing problematic areas, normally the deliberations of the states in a particular area are referred to as conferences. At times, a conference may lay down general norms which may later crystallize into separate agreements. For example, the World Congress on Human Rights in 1993 introduced a number of principles which later led to the adoption of independent conventions, resolutions and declarations by the United Nations on a number of areas of human rights. Resolutions. These are normally legal principles adopted by the Security Council, General Assembly or by any other body of the United Nations. These resolutions adopted by the UN are legally binding upon the states while dealing in their relations with each other. Charter and statute. Any legal document or agreement entered by sovereign states which lay down the principles about the functioning, structure and powers and functions of an international organization is normally referred to as a charter or statute. For example, the Charter of the United Nations, Statute of the International Court of Justice, etc. Executive orders. Executive orders are such orders issued by the sovereign authority of a state to give effect to the agreements that they have entered in, or if there exists a contrary on any aspect, they may state the policy of a particular state. These orders also play an important source in settling the disputes that arise between states in international law of human rights and other areas. Points to be remembered. In this lecture, we learnt about the terminology of various legal documents and their importance. The technicalities have been reduced to a great extent. Treaty means an agreement legally binding on the states to regulate their day-to-day relations. Bilateral treaty is an agreement entered between two or more states to settle the controversial aspects of international law or to lay down norms governing their internal relations. Multilateral treaty means an agreement entered between several states to be uniformly formulate rules of international law and its branches. Convention is another type of multilateral agreement wherein states lay down general norms of international law, especially under the auspices of an international body like the United Nations. Covenant is normally enforced under the aegis of an international body. After a state signs and ratifies, they are bound to adopt the provisions through municipal law to protect the interests of their subjects. Protocol is an additional legal instrument entered by states to rectify the defects in an existing document or to add additional provisions to an existing document. Charter or statute are legal documents which are entered by sovereign states to define the structure, powers and functions of an international organ. Resolutions are legal documents specifying or directing states with a set of legal norms to be followed. They are adopted by international organs and their agencies. Executive orders are orders passed by head of a state laying down their internal policy matters on international law. In conclusion, let me make it very clear that the legal instruments play a very vital role and they shape principles of international law of every branch, including human rights. Please don't confuse instrument means with a physical instrument. Here instrument means a legal document that need to be observed in view of number of documents are there. They are principally called as international instruments to be signed by the parties in order to maintain orderly regulations and to promote the principles of international law, especially that of human rights through the documents in which they entered. Thank you.